Hey guys, hopefully everybody had a good lunch and it just got dark here. Okay. Maybe it's the apocalypse or a cloud. It could be either one of those. So, what I'm seeing right now is still the seal, and I think I have it on correctly. So, I wanted to answer a question here that came up in the last stream that I tried to make a comment about it, but I'm not sure that I hit it. Somebody said, "Hey, there's a picture of these or a video of these police out there asking her questions, and she's answering them, and she admits to throwing this stuff on him. How can they admit that they didn't read her rights?" So, generally speaking, in a non-custodial interrogation, then you don't have to have the Miranda rights. So, if you take the person into custody, then you do have to do it. And the idea is that's when the person could be coerced by the police and stuff like that. So, if you're just standing out in a parking lot and the police officer walks up and said, "Hey, did you kill that guy over there?" And you go, "Yeah, I killed him," then that's going to be admissible against you. It's not going to be a situation where it's going to be excluded. But if they take you into custody and they keep you up for 3 days and they beat you with a fire hose, but they didn't read you your rights first, then yeah, you got a good case. So I'm still seeing the emblem, so I'm watching that. And they should be back any second, I think. Keeping a careful eye out for hot sauce stuff. Judge is running late, I see. And so we'll go there. Oh, well, yeah. I'll tell you what. Let me see if I can turn some lights on. That'd probably be good, wouldn't it? It's brighter. So I've offset the cloud there with some artificial lighting. Yeah, and okay, yeah, I want to get back on this discussion here. So I think that is wise. So hypothetically, if you think the police violate your rights there and ask you questions when there should have been a Miranda warning, you would do that in a motion in limine. That's before the trial starts, and then also object to it during the trial, hypothetically. Now, maybe they had a motion in limine and he lost because it was non-custodial, but he tried to ask the guy, well, she didn't really think she was free to leave, and maybe he's going to try and act like or get some evidence in that she wasn't free to leave so that he can have an appeal issue for her. So that might be why that would come up. But yeah, if you're free to go and they're just talking to you on the street and you go, "Yeah, I killed everybody and robbed that bank over there too, plus I did a bunch of other bad things," then the Miranda stuff is not going to be what saves you there. I mean, I respect the reason for having Miranda warnings and generally support it, but I'm not, every criminal a king kind of person where nothing can be used against them. So, the balance is it has to be custodial, because that's when the potential, pressure of being in custody and wanting to get out of custody and things like that, and feeling like you need to talk, then you need to read the rights there and have the waiver of those rights, not just reading the rights, but to have a Fifth Amendment waiver. So, yeah. Yeah, the old fire hose trick. They don't do that anymore. Nobody has a fire hose anymore. They have to use something new. They just don't give you the Wi-Fi password. I think that would cause a lot of young people to go ahead and roll over and say whatever the police needed them to say. And if you talk to us, I'm the good cop. I'm the good cop, bad cop. I'm the good cop, and I can get you that Wi-Fi password if you just tell me where the body is. I get your phone charged up too. I see it's at 2%. So we're not early. We're not late. We're early or on time, and the court isn't doing anything yet. Still trying to make sure I've got it on. I'm watching the stream down here because it just has the seal on it. So I'm kind of curious, what do people think after the morning? I thought the state closed fairly strong, in my opinion, with that video at the end of her lying to the police, unconcerned at her birthday party, knew her father was in the hospital, finally admitting that she threw this stuff on him. I think that looks very terrible for her. And remember, the statute she's charged under here is releasing or using a chemical irritant for an unlawful purpose, which can include reading it. I got it open on my second screen. To frighten, terrorize, intimidate, threaten, harass, injure, or kill any person, or any of those things meets the statute. And then based on what happens, the person's hurt, the person's seriously hurt, the person's killed, you can have a variety of punishment levels. And this one, because he died, could be life, but probably not going to happen. It's the first person she killed. Let's see. So I think the jury convicts here. That's just my opinion. Of course, that's why the defense gets to go. But what are they really going to be able to say here? I wouldn't be putting money on their case. And do I think she'll take the stand? So, house odds are always the defendant doesn't take the stand, because that's the general advice is don't do it. So if you say they're not going to take the stand, you're almost always right. Oh, look, we've got some activity coming here. It's not hot sauce, it's insurance, asset management. And yet the court's still not going. So you guys missed that commercial. If you need any asset management advice, just say it enough times and the algorithm will make sure that you get that. So anyway, yeah, I agree. She probably doesn't take the stand. Okay. But I remember the case here in Raleigh where the guy was in Virginia and drove here and beat his wife to death, and then drove back to Virginia to be late for a meeting. His pregnant wife, Jason Young, and he took the stand in his first trial, which was a surprise. And sometimes you can catch the prosecution off guard a little bit if they think you aren't going to take the stand. And he lied and lied and lied. However, they got a hung jury and they got to retry him, and then he was stuck with the bad stories that he told. So in the end, it worked out, and he's in jail where he needs to be. Let's see what else is going on. Well, I got the commercial, but they just wanted me to watch that. The court's still not doing anything. So it was a little bit tough to hear her talking in that video they played earlier, but I got most of it, I think. And once she admitted that she put the white stuff on him, she admitted that she kind of put it, that it got on the blanket, it got on his legs, some of it went on the sofa. So that's not just throwing a bottle at him. And then also she said, well, I just didn't think it would do anything if it was powder. And the police said, yeah, but you told us you threw water on him too, right? I don't buy that. Well, if I don't read the label and fully understand it, then I'm immune from the consequences of throwing it on somebody. It was as much of a defense. And there are, of course, many meltdowns by defendants. I will say that Young did a good job for himself. I mean, he's a lying murderer, so I don't mean good job in the sense of good, but he was helping himself the first time he testified, catching them a little bit off guard and telling some fresh lies, but it ended up backfiring. And then we had the case down the street with Nancy Cooper, who was strangled by her husband, Brad Cooper. And he ended up giving a statement in a deposition in a civil case, I think over child custody. He decided to contest that. Jason Young waived all that and also let a civil judgment be entered against him rather than say anything. Well, Cooper decided to fight for custody, I think was the posture of that. So they were able to get him on tape, given an accounting of what he was doing that morning. And that was where they got him on video at the Harris Teeter down the street from here, buying like some kind of cleaning thing and some juice at like 4 a.m. or whatever. And she was found down the street in a new development. Her body was found by somebody who was out walking a dog. So that was terrible. And that was a while back. He was somebody who, was just down the street. So I had, as it happened, I didn't know him, but I had done some events with him. They used to do triathlons, and he did too. And I think that was a case of domestic violence gone very bad, and a divorce situation going out of control, kind of like the Jason Young situation. But the solution is not to kill your spouse. Death till we depart is not a loophole. It's supposed to be a promise, not a loophole. All right, I'm still trying to get my mind back into this case a little bit, obviously, from lunch and waiting for it to start. I was hoping they'd start on time and then it could ease into the groove that way. So the posture is just before lunch, the state finished. They said they were going to call 2 witnesses. They did. They called the ER doctor. They called the trooper, and then the state rested. And now it is up to the defense make their case. And then usually what happens when they finish, typically, unless there's any rebuttal witnesses or whatever, then the state will make a closing argument. And then they can argue. And then the defense will make a closing argument. And then the state gets a little time at the end because they have the burden of proof. And I'm now working on getting this up here for you. And I will shut up.
Well, I wanted her to see her sister and her mother back there, and I wanted her mother and sister to see her as well, just to make sure. They weren't sure if they were going to break down in tears, and I'd rather have that done and they can't talk to each other, obviously.
Right.
But I just wanted to make sure that everybody was okay with it.
Okay. Are we ready to proceed?
We are prepared to proceed. I guess there was one issue that...
Hold on, let's go on the record. Go ahead and call the case.
Calling People versus Imirowicz, case number 22-281-519 FC.
Jason DeSantis, the people, Your Honor. Good afternoon.
Frederick, on behalf of Mr. Imirowicz, who stands to my left.
Good afternoon, Your Honor. Hunter Smith.
Megan Imirowicz.
Thank you. Everyone can be seated. Go ahead, Mr.
I think the
Your
father
Honor,
just had it there,
I
probably.
brought to Mr.
But I don't know.
Attention that
It would be
I
interesting if
became
she
aware
did buy it.
Julie Conrad, who's a witness on my case, had been watching court TV. Technically, there's a sequestration order, although she wouldn't have been here to see it. She didn't enter the courtroom, but these proceedings are made public, and I at least wanted to address it to the court because, frankly, it's never occurred. I've never had this situation, and I'm just bringing it out to the court's attention.
And Judge, I've never had this situation either. I do appreciate counsel for letting me know. At this point, I do have to move to exclude Ms. Conrad from testifying as it is a violation of the sequestration order.
Anything further?
Your Honor, I would just indicate that she's not going to testify as to what anybody else said. She's just going to give her observations of what occurred at that time, give her knowledge of Conrad Imirowicz, and she will not be commenting on anybody else's testimony.
With regard to People versus Marconi, 277 Mish App 651. At 6:54, the court is satisfied that there are 3 sanctions available for the trial court to remedy a violation of a sequestration order. Number 1, holding the offending witness in contempt. Number 2, permitting cross-examination concerning the violation. Or number 3, precluding the witness from testifying. Although usually stated in the context of a defense witness's exclusion in a criminal case, courts have routinely held that the exclusion of a witness's testimony is an extreme remedy. The court will not grant the request to exclude the witness. The court will, however, permit cross-examination concerning the violation.
Thank you, Judge.
Thank you.
So did you want me to call Miss
This seems fair.
Conrad?
Yes, you may.
Julie, this is without, you can stay there. This is without the jury, so come on up.
So is this the mother? I was thinking it was. Yeah. I don't know if it's the sister or the mother or whatever. See. And she knows probably she shouldn't be watching this on court TV. She should be watching this stream.
Can you raise your right hand and be sworn, please?
Under penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give this court today is the truth, the whole truth, and nothing but the truth?
Yes. Okay, ma'am, you can be seated.
Just kidding. She shouldn't watch any stream.
Okay. Deputy, can you just allow them to enter the courtroom, please?
Do you want the jurors in here?
Oh, I'm sorry. You wanted to do this before the jurors come in?
Well, this would be, that's a good question.
No, I would think the cross would be in front of the jury.
Go ahead.
All right.
With regard to sequestration, go ahead.
I could just go to credibility, Judge. That would be in front of the jury.
So he wants the jury in here then.
So I
Yes.
think we would just proceed as normal.
All right.
You okay?
I was going to call Morgan first, but
Okay, so do you want her to step down?
yes, I do.
That's fine.
Sorry, ma'am.
And it's a good practice run. She won't be quite as nervous the next time. Open the gate.
Okay, ma'am, and I'll have you wait in the hallway. Thank you. Mr. Miller, who are you calling?
I would be calling Morgan Imirowicz first,
Okay.
and she's seated
Right. So, ma'am, you want to come on up?
Do we want to bring in the jury first, Judge?
Yep, you can be ready right here, please.
So this is
Do you
perhaps the
jury know
sister.
to enter, please? Good afternoon, everyone. You can be seated, please. Okay, ladies and gentlemen, we are on the record. We have already called the case. The lawyers have put their appearance on. It is now Mr. Miller's case. He's calling his first witness. Mr. Miller, please go ahead.
I call Morgan Imirowicz.
Mr. Imirowicz, ma'am, can you please raise your right hand to be sworn? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Morgan, would you state your name and spell your last name for the court, please?
Morgan Imirowicz. IMIROWICZ.
Okay,
I'm
very
going to
good.
ask you to keep your voice up a little bit. I know this is hard, but if you can please make sure that you are speaking loud enough for everyone to hear in the courtroom, okay? Thank you.
And your relation to Megan Imirowicz?
This is my older sister.
Okay. Still got to keep it up. I'm going to come over here so you can speak loud. All right.
Okay, I'm sorry.
And your relation to Conrad Imirowicz?
He's my dad.
And he passed away in this matter, correct?
Yes.
And your relation to Austin Imirowicz?
He's my older brother.
And your relation to Julie Conrad?
She's my mom.
Okay. I want to draw your attention to the Austin's graduation ceremony. Do you remember that?
Yes, sir.
Do you remember when it was?
It was sometime late May, early June of 2021.
All right. That was before this incident, which we're here for, occurred, correct?
Yes, sir.
All right. On that date and time, did you see your father?
Yes, sir.
What did he look like?
Judge, at this point, I'm going to object as to relevance.
Yeah, seriously, come on.
Response.
Your Honor, it goes to establish that he had a drinking problem and clearly had some issues.
What's that got to do with
Judge, I
anything?
think the fact that he was drunk the night of is not really in dispute. I've certainly never disputed that.
Yeah,
Anything beyond that is simply character evidence from another date and time, which is only admissible in cases of self-defense.
Under 701, it'd be a lay witnesses. Go ahead, response, please.
Your Honor, I
Wow.
believe I'm going to establish his health, how he was throughout the last couple months of his life.
Not a fan of this.
Indicate that he had a serious problem.
The problem was he had poison poured all over him. Wasn't that kind of the problem?
Mr. DeSantis, sir, why wouldn't it come in under 701, please?
Judge, it's character evidence of a witness that isn't material to credibility, so it doesn't come in.
Yeah, how he was drunk at some party or whatever. What's that got to do with this? Unless he
And it's
did something
also
to her.
specific instances of conduct. So if you want to attack credibility with extrinsic evidence, it has to be done when it's concerning the witness's character for truthfulness or untruthfulness, or concern the character for truthfulness or untruthfulness of another witness to which the character witness has been cross-examined as testified. That's not the case here.
Technically, Mr. Imirowicz isn't a witness, although he did get statements in.
With regard to the issue of being an alcoholic and the specific facts of this case, tell me why it would be relevant in this case in order for me to establish whether or not it's appropriate under the lay witness opinion testimony of 701.
Your Honor, Austin Imirowicz testified that there was nothing wrong. His father was fine. There was no problems at all.
What was the date of the party or the ceremony that you
The
reached?
ceremony was the spring of 2020, which was
2021, sorry.
2021,
2021.
which was just a few months prior to.
Court's gonna allow it.
Thanks.
What, if anything, was the condition of your father on that date and time?
He showed up late. He had half his head shaved, buzzed on one side, so like almost skin,
I
and it was
hear
longer
this,
on
but
the
I
other
don't
side.
know that's
And
relevant,
then
but we'll
he
see.
had a white shirt on it and it had stains on it.
Did you get close enough? Did you talk to him that day?
No, sir.
Keep your voice. Okay. All right. Had you ever been in the house?
Yes, sir.
When was the last time you were in the house?
The summer of 2021,
What was the condition of the house?
very poor. It was very messy. Smelled very bad.
I walked in. When you walk in, there's a stairwell, and I was just on the hallway, and you could see that there was trash everywhere.
And you had actually spent the night there, correct?
Not during that time. The last time I spent the night was my freshman year of high school, so 2018 through 2019.
And at that point in time, you indicated that the downstairs bathroom was pretty bad.
Yes, I showered in it, and there was vomit in the shower and in the sink, and there was toilet paper everywhere.
And that was your father's bathroom.
Yeah, I shared it with my father because my room was on that floor as well.
Did you ever try to visit your father in the hospital?
I tried one Saturday with my boyfriend, and I was told I wasn't allowed to
By the hospital staff.
by my brother.
Thank you. Confirmed.
Morgan, my name is Jason. I'm the prosecutor in this case. If you can't hear me, you need me to repeat a question, just say so. Okay?
That wasn't much of an exam, so it's all's well that ends well.
You weren't there on the night of October 1st, 2021 at your father's house, correct?
No, sir, I was at a football game for my school.
Okay. Were you living at home with your mother?
Yes.
And that's Julie Conrad?
Yes, sir.
Okay. After Megan was arrested in this case, she came home, right?
Not that night, but a few days following, she came over to our house, yes.
Okay. And so then she was staying with you for a while.
Yes, sir.
Okay. How was your relationship with Megan before this?
Before the incident?
Yes.
We were very close throughout childhood. We always shared a room. The only time we didn't was when my dad let me have my own room at his house and when my mom let me have my own room at her house. So I was around 10. And then we always stayed in contact even though we weren't living at the same house anymore. And that started when I was 13, almost 14. It was during the summer. My birthday's late summer. But we always talked. We always called. We had classes together our freshman year of high school. So we were always together in those classes, sat by each other.
Okay. That sounds like a very close relationship.
Yes, sir.
It seems you did not have that relationship with your older brother, Austin.
I did for many years, but it faded out in and out. We just didn't have that bond that my sister and I had.
Okay. When you were trying to get to the hospital to see your father, you said Austin was the person who told you no.
Yes.
Okay. At that point, had Megan already been staying at your home?
I do not believe so. I think because she came home on a weekday and that was the weekend.
Okay. Had you talked to Megan already?
No.
Okay. I don't have anything else to do.
Just briefly, you'd indicated you guys lived together for a while, correct?
Yes, sir.
Was there a point in time when there was a divorce in this matter?
My parents were divorced when I was in kindergarten, and they started living separately when I was in first grade. So
And Megan,
2011.
okay, now, Megan and your brother lived with you for a while, correct?
Yes, my mom had primary custody, I think it's called, because they had joint custody of us, and we would go back and forth between the houses on Wednesdays, and every other weekend we were with my dad, and then every other day and weekend we were with my mom. And that stopped occurring the summer before my freshman year of high school, so when I was 13.
And at that point in time, Megan and your brother moved out?
Yes.
Okay, thank you. Nothing further.
Briefly, Judge. Did Megan choose to go live with her father?
Yes, we were all given a choice of what parent we wanted to live with.
Okay. And you chose to stay with your mom,
Yes, sir.
and Megan and Austin went to live with their dad by choice?
Yes, sir.
Ladies and gentlemen of the jury, do you have any questions? Okay, you're excused as a witness. You may step down.
Your Honor, may she stay in the courtroom? I'm not going to recall it.
Any objection?
I won't be recalling her. I have no objections.
She may stay in the.
But that wasn't too bad on the drinking front. It didn't go as bad as I thought it might. So no real issue with it. But boy, these witnesses go by fast in this case.
Thank you, Mr. Miller.
So I think the mother comes next. Take her name down.
Morning, or good afternoon, ma'am. Can you state your name again for the record, please?
Julie Conrad.
And raise your right hand to be sworn.
Do you solemnly swear affirm that the testimony you're about to give before this court is the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated, please.
Thank you.
Ma'am, would you state your name and spell your last name to the court, please?
Julie Conrad. JULIECONRAD.
And your relationship to Megan Conrad, or Megan Imirowicz, excuse me.
She is my daughter.
And your relationship to Morgan Imirowicz.
My daughter.
Your relationship to Austin Imirowicz.
My son.
And your relationship to Conrad Imirowicz.
My ex-husband.
All right. And you would talk to Conrad occasionally, would you?
Yes.
I draw your attention to that night, October 1st, 2021. Do you remember what occurred?
Yes.
Did you receive a call?
Yes.
And what did you do?
The phone call was from Austin for asking me to go to his father's house and to pick up Conrad's cell phone and to bring it up to the hospital.
All right. What did you do first? Did you go to the house or did you go to the hospital?
First, I called another adult to follow me over to Conrad's house, and we went into the house with the other adult, always within a few feet of me. In fact, one time even so close that ran right into him when I turned around real quick. And then he followed me back out to Grange Hall Road, and I headed up to Genesis, and he
Okay.
headed home.
All right. So you were in the house with another individual, correct?
Yes.
What was the condition of the house?
Have you seen the show Hoarding?
Go ahead. Well, I don't
A
know.
lot of trash. You could not walk into the kitchen. There was trash bags and various trash all over. To the couch, there's just a little, like 1 foot wide trail to the couch, to where Conrad was sitting that day, on the left side of the couch. Austin's bedroom, I believe, was pretty much empty. Megan's bedroom was a mess, but just clothing. Um, the bathroom, it needed a good cleaning. And the downstairs, the lower level, the bi-level, the basement, it smelled a lot like cat urine, cat feces. Um, the lower level bathroom, I gagged, and that's when I turned around and ran into the other adult, as the toilet was full of feces, and it really smelled bad. Um, with Conrad's bedroom, there was not a bed, um, and the freezer was open a little bit, and that's the only thing that we touched other than the front doorknob. We closed the freezer to preserve the food.
And you indicated there was an odor in the house?
Oh, yes. I mean, it's a combination of cat smell. I know there was mold because my eyes started itching and the roof of my mouth started itching. And that only happens when I'm around mold.
What did you search for when you were at the house?
Well, first we were looking for a cell phone, and that was pretty easy to find as we stood at the top of the stairs, and I called Conrad's cell phone number. And a piece of paper started moving around on a table. And so we went over and looked underneath the piece of paper, and I was able to grab the cell phone. And we were also looking for what kind of chemicals, because if he had chemical burns, as a ski patroller for 23 years, it's important to know what he's burned by so he can be treated properly for those burns. And so we were looking for what type of chemicals and taking pictures. And all the pictures I shared with Trooper Smith when they arrived up at Genesis.
Did you observe the white bottle?
I never saw a white bottle.
Did you look at the couch?
Yes.
Was the couch damp in any way?
It looked like it was well sat in certain areas.
It's clearly damp in the picture, and I wasn't even on a ski patrol.
It was an older couch, and it looks like the areas where people would sit for, days, years, were kind of like, it was a different type of, the fuzzy part of the material wore off.
Now, did you observe any liquid on the floor?
The carpet was definitely wet. There was plastic bags all around right in front of the couch, and I stepped on one. I thought it was cat feces. There were not any tigers there, so I don't think it was cat feces.
It was feces of some kind?
I think it was human feces.
After you looked for the chemicals and you found the phone, what, if anything, did you do?
Well, we took the pictures. We did see a powder like on the back of the couch, like where your head would rest. We did see powder there. So I took a picture of that. And again, that was one that I texted to Trooper Smith. And we just, any type of chemical product we took a picture of. And then after that, we went ahead and left.
Where'd you go next?
Back out to Grange Hall and up to the emergency room at Genesis.
What happened when you got to Genesis?
I saw Kayla, who I recognized. And so I walked right up to her And she goes, okay, well, let us call Lucas out so you can go in. And so we kind of did a switch there, and I went in and was in the room with Conrad and Austin, and medical people were coming in and out.
Did you have a chance to talk to Conrad?
Yes.
What, if anything, did he tell you?
He's like, hi. And he was very animated. And knowing Conrad, so I knew what condition he was in. But he's like, how are you doing? And I'm like, I'm fine. How are you? And I was like, does anything hurt? And he's like, no. I'm like, well, what happened? He's like, I don't know. I'm just here. They're giving me meds and stuff, and everyone's coming to see me. And he was like having a jolly old time.
Okay. Did he ever at any point in that day tell you anybody did anything?
No. He just kept repeating, I don't know. I don't know. And he said he actually showed me many of his burns. And I was feeding him ice chips.
It came at one time when you left, correct?
Yes. The hospital staff was rounding everything up and getting everything ready so he could be put onto the ambulance for transport to Hurley.
Did you ever talk to him after he left the hospital?
No.
Did you ever try and visit him?
No. On the next day, I had set up a text chat, real text, not Snapchat, a text group with Austin, Morgan, myself, and my youngest son, Ian, so we could get updates on their dad. And I ended up calling Austin, and he told me that a plan was put in place where no one could come up there except for himself and one other. And you had to have the passcode or the password in order to get any information or to visit. And he told me I better not ever try to go around that. He goes, I know you're good at talking your way into things, and not to ever come up there or do anything or you're done for.
So did you ever talk to Conrad after that date and time?
No, I never talked with Conrad after he left Genesis.
All right. Now, Conrad had some health issues.
He'd had issues for many, many years.
All right. You were married to him until when?
The divorce was final May 2011. I'd moved out of the house into my own house in December 2010. And that was after custody was established.
When you were divorced, what, if any, medications was he on?
He was taking a blood pressure medication and a water pill.
I'm sorry, I didn't quite hear that last one.
I'm sorry?
I didn't hear the last answer.
Oh, he was taking a blood pressure medication and a water pill. He also took an over-the-counter allergy medication and an allergy medication that is a nasal spray.
Do you know if he continued those after the divorce?
I would have no way to know.
All right. And you would talk to him occasionally, correct?
Yes.
You had children together with him.
Yes.
Did he ever discuss his health with you?
Yes, he did. Actually, that summer he had discussed his health with me. He called up and asked me, I could tell he was sort of embarrassed, and he asked me why his urine would be dark brown, almost black, and very difficult to, I'll use the word, urinate. And I told him right away that he needed to go get some, emergency help. he needed to go to the hospital right then.
To your knowledge, did he ever go?
I have no idea. I had kids to take care of.
Sure. And there came a point in time when, originally with the custody, you were granted custody of the kids, correct?
Yes, I had primary custody. The kids were with me every Wednesday evening. Conrad was supposed to pick up the children from school and drop them off. It began at 7 p.m., but as the kids got a little bit older, it changed to 8 p.m. And then he had them every other weekend from right after school through the Monday morning when he dropped them off at school.
There came a point in time when that changed, correct?
Correct.
And what? Do you remember when that was?
Yes, it was right when my mother was in the hospital for cancer. It was February 2019. And the kids were talking about living with Conrad. Well, the motion that he filed was for him to have full custody of all 4 children.
And what was the result of, what was the end product of all the court process?
Okay. The end product was that he had custody of the older 2, Megan and Austin, 100% of the time, physical custody. I had physical custody of the younger 2, Morgan and Ian, 100% of the time. Now the children could decide when or even if they wanted to see the other parent. It was up to them, with the one exception being Christmas Eve, they had to be with their dad, and Christmas Day, they had to be with me.
And Mr. Nothing else, Your Honor.
Thank you.
And Mr. Nothing Else, Your Honor. Another short one.
Good afternoon, Ms. Conrad.
Good afternoon, Mr. DeSantis.
If I've been told I talk a little fast sometimes, so if you need me to repeat anything, just
That is true.
Oh, I'm used to my chipmunk moving.
Sure. So your children in order of age would be Austin, Megan, Morgan, and Ian.
Yes.
Right. How old would they have been on October 1st, 2021 each?
Okay, this is a quiz, isn't it?
No, it's not. I promise. Just to
Okay.
establish the relationships.
That would have been 2 years ago. 1 year ago. So Austin would have been 19. Megan would have just turned 18. Morgan was 17. And Ian was 13.
Now, the day of the incident.
Pretty good
October
throughput
1st,
on these
Yes.
kids for a while.
You went over to the house with another person. Who was that?
Evan Sweeter.
Okay, Evan Sweeter.
Yes.
And what was his relationship to you?
Actually, someone who helped me out a lot, but Morgan's boyfriend. But he was 18
Okay.
and therefore an adult.
Okay. So you had Morgan's boyfriend come with you to this house.
Yes.
Okay. Was he at the home when you had been called?
No.
Okay.
But as soon as I hung up from Austin, I immediately called Evan, and Evan's house was actually on my way to Conrad's.
Okay. When Austin called you and told you what had happened, and you went over to the house, what information did you have going into the home?
I knew that Conrad had been burned by some type of chemical. I knew that they were at Genesis. I knew that Megan was having problems with the PIN number on her dad's credit card, and that my dad was also involved, and he ended up actually paying for the hotel room on his credit card.
Wow. That's what's really important here, is using someone's credit card for
I think
your
that's
parties.
all I knew.
Okay.
That's important. That's
What Austin
matters.
asked you to do was go and get the phone, right?
Yes.
Okay. Did he ask you to do anything else?
Yes, he asked me to see what chemicals were around
Okay.
so we could figure out what was put on them.
Okay. So you went in there and you started searching through.
I mean, walking through, yes.
Okay. Did you move anything aside to try and find any chemicals or anything like that?
No.
Okay. Did you see the blanket on the couch?
There was a lot of stuff wadded up at the right end of the couch.
Okay. A lot of stuff wadded up the right end of the couch. You didn't search through that pile, though?
No.
Okay.
No, we didn't want to touch anything.
Okay. So you didn't know if there could be a chemical bottle in the couch?
No idea.
Okay. You said the floor was wet?
Yes.
Okay. And that the couch was certainly discolored?
Well, it was worn.
Sure. Okay. But you used the word well sat in, I think, right? Is that what you said?
Yeah.
Okay.
Yeah. I mean, it's
And you saw white powder on the back of the couch?
on the on the area behind the couch.
Okay. Then you said you also went and saw, and then you left after that.
Mm-hmm.
Is that a yes? Just for
Yes.
that's okay. 20-year officers do that as well. And then you went to the hospital.
Yes.
Okay. And the person who was with you left, didn't come with.
Correct. He went back to his house.
Okay. Why didn't you have him come with you to the hospital?
He had to actually wait and pick up Morgan. From, I believe Morgan was at a football game at the high school.
Okay.
And so he had to wait and pick up her.
All right. And so you went to the hospital
Yes.
and you went in and saw Conrad
Yes.
and you said he was having, I think it was a jolly old time.
Yeah.
Okay. He was medicated then, wasn't he?
I did not see for sure that he was medicated, but I'm sure he was.
Right. You weren't there when he was first picked up, of course.
No.
All right.
No.
When did you get to the house?
I got to the house at around 5:30, 5:20. I think it was 5:20.
Okay. Was it already dark out?
No,
It was October 1st, so it's
Yeah,
kind of in between, right?
you're right. It wasn't dark yet.
Okay. Now, after the case was over, well, let me ask you this. First off, you talked about the custody split at the end that changed in February, correct?
Yes.
So that the physical custody changed.
Yes.
So did Megan and Austin choose to go and live with Conrad?
I asked each child what they wished and what did they want because they were all, old enough to make the decisions. And so I did what they all wanted.
So about that time, Megan would have been what, 17?
No, in 2019, she was 15.
Okay, she was 15. And so you thought she was old enough to choose which parent she lived with?
Well, I understood that around age 12 and depending upon maturity level, that they can start having a voice in where they want to live.
Okay. And so she chose to go with Conrad?
Yes.
And that was the agreement that was set then?
Yes.
All right. After the case began, after this incident happened, Megan came home for a while, right?
Megan came to my house. Yes.
She came to live with you?
I picked her up from the jail.
Okay. Did she tell you what had happened?
First we hugged and cried.
Sure.
And then she asked, is her dad okay? And I showed her 2 pictures that I had taken of her dad.
What were the pictures of?
One was of his head and the burn on his head. The other one was of, I don't remember if it's left or right, but of one of his hands where the cuticles were all pulled back and the burns went out about to the middle of his fingernail.
Why did you show her those?
So she could know what condition her father was in.
Okay. And then you brought her home?
Well, we talked a little bit more first.
Sure.
Um,
Overall, you brought her home?
yes.
Okay. And so she was staying with you for a while?
Yeah, she stayed with me until March, I believe it was March 16th.
Okay.
Now, I assume, when you first took the stand, counsel was asking you about your kids and naming them off, and you had an evident smile on your face. I assume, you love your kids. I assume
Yes.
Megan was always welcome at home, right?
Yes.
Okay. And you've been talking about, and we've heard in this trial, in fact, you heard in this trial because you were watching on the stream, right?
I watched the first day I did not
Waffling.
really watch too much of it, and then some of it I was not able to watch at all. There's a few testimonies I saw all of them.
Okay. So you were talking today about the mess of the house.
Yeah.
Okay. And it had been in that condition for some time.
Well, there was one point in time many, many years ago that I actually went over and said, I'll help clean. And after about 10 hours of working, I had only cleaned the boys' bedroom.
Sure. That was years ago.
That was years ago.
Years prior to this incident, prior
Yes.
to 2021.
Yes.
Okay.
Yes.
And so despite this, Megan chose to live with her father.
Yes.
Okay. And while this was all going on, she never came home until this happened. She never came to your place, right? She never moved back in.
Once in a while she would come over.
Sure, but she didn't move back in, right?
Correct.
Okay. She chose to stay there.
Yeah.
Okay. Megan is, of course, your daughter. You love her very much. You don't want anything bad to happen to her, right?
Correct.
Nothing else, Your Honor.
Boom. That's it for that.
Do you have questions?
Okay, you can step down. Your excuse as a witness.
No question by the jury. Well, it was interesting. There's a lot of things going on that aren't being said, which I think is good, but also, it's fairly benign testimony. And he wasn't in the best health. He clearly was having issues. That I agree with what some people are saying, that could go towards punishment eventually. I don't know that or see how it would excuse her for the crime. Yeah, no. Looks like she's crying a little bit there. Of course, it is a terrible situation. And then I think she wasn't supposed to be watching this on court TV until she testified. So that was bad.
Ladies and gentlemen, we are concluded for today. I will have you come back
Wow.
tomorrow. Nine o'clock?
That's fine.
9 a.m.? Okay, we will start tomorrow at 9 a.m. Thank you, ladies and gentlemen. Remember, do not discuss the case with anyone. Do not research anything. Don't have any discussions with regard to this matter until I instruct you and you are clear. Thank you, ladies and gentlemen. I'll see you tomorrow morning.
Eyes for the jury.
So her testimony is not going to be thrown out. The judge mentioned that she had a range of sanctions, and what she decided was if you want to impeach her about it on cross-examination, you can. And I think, that's the right answer here. Nothing really turned. She wasn't any kind of explosive witness with saying some incredible quote from somebody that would change the case. It was a little much the same of the rest of it. Hey, he was a drunk and he was super messy and it was terrible. And I think, unfortunately, this is probably somewhat accurate here. And I don't know why. I got the sense this wasn't the first time that there was a raged out incident between the daughter and the father, and it just didn't involve this kind of result in the past. That's my impression, at least. So I would tend to agree here that this didn't come out of nowhere. So that's it. They finished with the two witnesses the state had, and the two witnesses defense had. And I didn't hear whether the defense said that's it. That's all we're doing. I just heard the judge say we're done for today. So I don't know if they have any more witnesses that couldn't get here. today that they want to have tomorrow, or if that's it. I have no idea really what's going on, because usually also when you get this close to the end of the case, there's some discussion about jury instructions and things like this. Maybe they've already done that, or they're just not going to do it on the stream. I don't know the answer to that, because this case is rocking toward its closing arguments pretty quickly. So I agree with people saying that a lot of things the defense were bringing up really have to do with how much punishment she should get. Again, the element of the crimes, or the major crime that she's accused of is, I'm going to pull up the statute right here. A person shall not use or release for an unlawful purpose any of the following. And one of those is chemical irritant. That's what this was. And if it results in the death of somebody, you could face up to life imprisonment, although I don't think that's, it's not going to happen here. And generally, this is true. I mean, if the daughter had this rage issue or whatever, maybe that should have been dealt with more adequately earlier. And maybe it couldn't have been, I don't know. But with the father's house in the shape they say it was in, and yet kids choosing to live over there, a lot of things obviously unsaid. If he's the alcoholic he said that they say he was, and it appears that's mostly accurate, his house in the condition that they say it was, how in the world is he in the position to file any kind of motion to take full custody of all the kids? So there's a lot bad in that family that doesn't need to be on the internet. It's just the case itself is really enough, right? She threw this stuff on her father, and it looks like that's pretty clear at this point with his, if there was a bombshell, it was the video they showed this morning where she's telling the police, yeah, I threw bread on him. That's all I threw. And they're like, you threw something else. She's like, well, yeah, I threw water on him. And they're like, you threw white powder on it. Well, yeah, I did sprinkle that all over the place. And yeah, might have been a cleaning thing, but I didn't think it would do anything just by itself. Not good. I'm saying rage, and I'm saying that because of in the video earlier, and with the friend and stuff, she talked about, and I think she told the police too, that she got really mad. And it was more than one place, but this morning, that police video, and she was yelling at the father and stuff like that. So that's what I mean by that. That before she was throwing anything, she got angry and was yelling at him, and then threw things at him. And I doubt that's the first time that's happened. I think it just was the time that it happened with something with such a catastrophic result. So, I haven't heard the defense make this argument yet. I don't know that they can. When the bottle says on it, danger, poison, will cause severe burns, and it's in all capitals in the font with a skull and crossbones, and you pour it on somebody, I don't think you have to know anything else about it. I mean, the statute just says a chemical irritant, and you have some responsibility for that. And then it harms somebody and you're held responsible for it. That would be relevant, I think, to a penalty, but it'd be kind of like saying, well, I was driving a car and I hit somebody. I didn't really know a car would hurt somebody. It says it right on the bottle. That's going to be the problem for her, I think. That's my opinion anyway. Well, that's terrible, but there seems to be some indication of that, and a split with the kids and stuff. So all that stuff is just awful. And as much as, I'm not going to excuse her behavior in this, but is it relevant for the judge when it's decision time on punishment? I think all of that is relevant. So we'll see. Yeah, that would be a good one, except, I put that label on earlier this morning, and for the thumbnail for this morning stream, and I don't know that you can make a clearer label than that one. Yeah, this is a good point here. If there were consequences, they don't appear to be effective, but we all know that sometimes kids in a divorcing family like that can run the gap between the parents, even when they're not divorced sometimes. And if they have behavior problems, they don't get addressed like they need to. And so there you go. Again, not excusing her for what she did. Yeah, they showed the bottle yesterday, a pretty good picture of it. They didn't show as big a picture today, but I found that exact product for sale on the internet, and so put that label onto the stream for this morning. And then when the guy read it this morning, it was also exactly the same thing. So big skull and crossbones on the front, and danger, poison in large font, will cause severe burns. Read all instructions. There's more things and stuff. So I don't think she has to know how bad it would be. She just has to know it's a chemical irritant. That's what the statute says. And if you do it to harm or harass somebody, then what the result that flows from that is the result that flows from it. So I think that's a big problem for her legally. So I don't know if she wanted to hurt her father or not. I don't see any evidence she wanted to kill her father, right? And whether she wanted to physically hurt him or not, yeah, who knows, right? I think that's where it comes down to the punishment phase, because the statute doesn't require that you intended to hurt somebody. You could just be to harass somebody. There's a lot of words there, and there is no good reason, I think, to pick up a bottle that has a big skull and crossbones on it and says it will burn people and put it on somebody that isn't a negative thing that you're doing for the person. You're not doing it to celebrate with them. You're doing it and she said she was mad when she did it. So when you pour things out of bottles on people when you're angry, you are probably doing it for a negative reason. And I think that was what the reason was. That's how I would see it if I were on a jury. And that's why they have a jury, because they'll have 12 people think about these things like we're doing, and they'll all talk about it and make a decision. So that's it. So if I can, I'll try to get on this case tomorrow, because I think it'll just be over pretty soon. And if I can, I will post it up thumbnail and see you guys in there. Enjoyed talking to everybody in the chat, and thanks for coming in. If there's any legal questions that I think I could answer, let me know in the comments and I will. We talked about how I think I got early in this before the judge came on of why they were able to use her statements to police before they read her any Miranda rights. So that's at the front end of the stream. I think that's probably about it. Also in the first session, I think showed the statute and the definitions and read them too. So those are the kind of the two operative things going on. All right, guys. Well, thanks for the comments and different points of view and stuff, because if you're not being challenged in your thinking, then what fun is life? All right. Have a good day. Thanks. Bye.